All right, good morning, everyone. My name is Marcus Campbell from Miller Johnson Employment Section. I have Keith Eastland, who is here with me today as well. And we're going to be discussing the ins and outs of the enhanced unemployment benefits under the CARES Act, which recently was passed. And we're also going to be discussing some strategies for handling employees, your essential workers, that are refusing to come to work due to fear of the coronavirus or many various issues. If we can get the next slide, please. All right, now, today's agenda is we'll deal with the CARES Act and the enhanced unemployment benefits. Those of you that were at the 8 a.m. webinar, you got a good rundown of the CARES Act. But we specifically saved all the details relating to the enhanced unemployment benefits for this webinar. And I'll provide you some general information. Then we'll talk about the 3 different types of benefits that were approved under the CARES Act. And then after that, we will talk about what we can do when our essential workers will not come to work. That has been a problem that many of our clients have been getting since this all began, and we expect that to further increase with the increase in unemployment benefits that are likely to come within the next few weeks. If we could get the next slide, please. All right, let's talk about the CARES Act enhanced unemployment benefits. This was passed last Friday. It's about a 900-page bill. Everybody is still digesting it right now, trying to figure out exactly what it does, exactly how it will be implemented by the states. And but generally speaking right now, it is going to provide enhanced unemployment benefits to different types of individuals. First of all, it's going to provide state unemployment insurance benefits to individuals who normally cannot receive unemployment benefits. It's also going to provide an additional $600 a week to everyone who would be receiving unemployment benefits. And then on top of that, it provides 13 additional weeks of benefits once individuals have exhausted their right to state unemployment benefits. Can I get the next slide, please? All right, the first section that we have, I tried to break this down because it is a very complicated bill. The first section that we will deal with is the first type of benefits that are provided under Section 2102 of the Act. This is called the Pandemic Unemployment Assistance Program. Section 2102, I entitle it Unemployment for People Not Normally Eligible for Unemployment. This means sole proprietors, individuals that are independent contractors, gig workers, certain agricultural workers, LLC members, partners and partnerships, church employees. Those individuals normally cannot establish what we call a base period. They are not eligible for unemployment because they don't have any wages reported on them to the Unemployment Insurance Agency. So this is a group of workers out there who are normally not eligible for unemployment benefits. Now, based on the CARES Act, they will be eligible. And I see a question from Amanda out there that says, what impact will this have on my 1099 contractors? Well, what that likely means is the 1099 contractors that you have out there will now likely be able to get unemployment benefits. They'll have to meet various criteria, which I will go through, but in previously, independent contractors or 1099 workers, as they're sometimes called, couldn't get unemployment. They can now. This is something that they're now able to get under Section 2102 of the CARES Act. Can I get the next slide, please? All right, who can collect these benefits under Section 2102? The individuals must, 1, not be eligible for normal state unemployment insurance benefits. They must be able to perform work. They must be available to perform suitable work. And they must self-certify that their unemployment or partial unemployment is related to COVID-19 in some way. Can I get the next slide, please? Now, there is a number of factors. I'll briefly go through them right here, but for anybody who is an independent contractor or people who are normally not eligible to receive benefits, they are going to have to self-certify that in somehow their unemployment or partial unemployment is related to COVID-19. Some of the factors I'll go through briefly. They were diagnosed with COVID-19 or they're experiencing symptoms of COVID-19. A member of their household has been diagnosed with COVID-19. They are caring for a family member or a household member diagnosed with COVID-19. They are caring for a child that is unable to attend school due to a COVID-19 public health emergency, and sending the child to school is required for that individual to work. Next slide, please. The individual cannot reach work because of a quarantine due to COVID-19. The individual was advised by a healthcare provider to self-quarantine due to COVID-19 concerns. The individual was scheduled to commence employment and does not have a job and cannot reach it due to COVID-19. Or the individual has become the sole breadwinner of a home because the previous breadwinner died due to COVID-19. The individual has quit their job as a direct result of COVID-19. The individual's place of employment is closed due to COVID-19. The individual meets additional criteria described by the Secretary of Labor, or they are self-employed and are seeking part-time work, but do not have a sufficient work history to qualify for regular unemployment benefits. Can I get the next slide, please? So what does that mean? That means that if you are normally ineligible for benefits, if in any way your ability not to work now has just about any relation to COVID-19, that means you will be eligible for these benefits. Except it does not include anyone who has the ability to telework, which essentially means work from home and receive pay for working from home. Those individuals are excluded. Under this law, they expect those individuals to continue to work from home. Also, it does not include anybody who is receiving paid sick leave or any type of other paid leave. So while these individuals are receiving any type of paid leave, then they will not be eligible for Section 2102 benefits. Now, how much is the benefit? The 2102 benefit is going to be the state unemployment benefit amount plus $600. Now, in Michigan, laid off workers can receive up to $362 per week in state unemployment benefits. That will have an additional $600 added to it. So that means employees that are laid off could collect up to $962 per week. Now, how long do these benefits last? The statute says they last up to 39 weeks until December 31 of 2020. Now, is it retroactive for these individuals, your independent contractors, etc.? Yes. The statute says that is retroactive back to January 27, 2020. Now, the additional $600, it's not 100% clear, but I'm certain that even for these workers, that is going to currently expire on July 31. So any type of contractors or anybody who is now eligible for unemployment and they are collecting them under Section 2102, I believe the additional $600 will expire on July 31st. That's not 100% clear, but I'm pretty sure that that is how it's going to be interpreted. Can I get the next slide, please? All right.
Marcus, Marcus, I'm sorry to interrupt, but just real quick, I want to make sure I understand this and the audience does. So the 2102, all of that you just talked about, likely will have fairly limited application for most of our clients who are worried about their employees. Is that right?
Yeah, I believe so. If you have a lot of 1099 contractors that you work with, then it will have some application to you. If you do not have a lot of them, then the Section 2102 benefits really don't have much application to your workforce.
Great, thank you.
Yes. And so the next section, this is a section that's going to impact most employers' workers that are receiving unemployment or could potentially receive unemployment in the future. And that's section 2104. That's the emergency increase in unemployment benefits. What this is, it's extra money for individuals who are normally eligible for unemployment, and it provides them with an extra $600 per week. This is going to cover most of the employees who earn W-2 wages, which is the vast majority of individuals. So this is the section that is going to be most important to most of your workers who are either laid off now or may be laid off in the future. Can I get the next slide, please? All right, individuals that can collect the Section 2104 benefits, those are individuals that are normally eligible for state unemployment benefits. And since state law applies, those individuals cannot be disqualified in accordance with state law. According to the statute, I'm not sure how it will be interpreted by the states and administrators, but these 2104 benefits are not linked to any COVID-19 criteria that I say. So while you need that criteria, if you're an independent contractor or somebody who's normally not eligible for benefits, at least according to the statute right now, you do not need those to collect the extra $600. However, the individual who is not eligible under state law or is somehow disqualified cannot receive the Section 2104 enhanced benefits. Can I get the next slide, please? Now, how much are the 2104 benefits? They're the exact same amount as the 2102 benefits. It's your normal state unemployment benefit amount plus $600 per week. And as I said before, in Michigan, that could be up to $962 per week. Now, it's important to know that they cannot be disqualified in accordance with state law. And as I said earlier, the 2104 benefits are not linked to COVID-19 in any way. How long will the 2104 benefits last? According to the statute right now, they will last until July 31. So anybody who has been recently laid off, who's receiving unemployment, will receive their state unemployment plus $600 up until July 31st. Can I get the next slide, please?
Yeah, Marcus, before we move on, I just want to ask or make a point, I guess, is when we say they're not linked to COVID-19 reasons, we mean the specific reasons in the federal law. Of course, many of you are aware that there's an executive order in the state of Michigan, and the state of Michigan, its eligibility has been expanded to cover those COVID-19 reasons. So when we're talking about not linked, we mean not linked to the federal enumerated reasons, but obviously state law can still have COVID-19 reasons supporting unemployment.
You bet, absolutely. And since the state unemployment laws have been expanded so much due to COVID-19, the employee doesn't have to say much except COVID-19, and they'll be eligible for unemployment benefits. That's simply where we're at. But yes, the factors listed in the federal statute technically do not apply to anybody, but any other reasons under state law, those will factor into the 2104 benefits. Now, the next type of benefits that are provided are the Section 2107 benefits, called the Pandemic Emergency Unemployment Compensation Benefits. What this is an additional 13 weeks of benefits that is applied as soon as anybody exhausts their normal state unemployment benefit amount. Now, in Michigan, currently, right now, there's 26 weeks of benefits that individuals can receive. And what this will do is once those are exhausted, it provides another 13 weeks of benefits. Can I get the next slide, please? All right, so 2107 benefits apply to individuals who have exhausted their regular unemployment compensation, or have no right to any other compensation, are not receiving any type of Canadian compensation, and are able to work, available to work, and are actively seeking work. So as we talked about earlier, the 2107 benefits are also not specifically linked to the federal criteria, but any state criteria that allows somebody to get unemployment benefits for COVID-19 related issues, those still apply. Can I get the next slide, please? All right, how much are the benefits? The 2107 benefits are exactly the same as the other two. You get your state unemployment benefit amount plus $600 per week. In Michigan, that could be up to $962. Now, how long do these benefits last? They last 13 weeks. So that's an additional 13 on top of the 26 that you're already getting. Can I get the next slide, please? All right. A question that I've been getting a lot is, are employers going to be charged for these benefits? If you're a contributing employer, your account gets charged for these benefits at the UIA, which could raise your overall tax rate. If you're a reimbursing employer, that means you normally get a bill for these type of benefits. And the question is, are we going to get charged for all these benefits, including the additional $600 a week? It is completely unclear right now. We have no idea if you are going to get charged for these things. Contributing employers, my position is I do not believe your accounts will be charged. Now, that is based on the governor's most recent executive order, and that's also based on the fact that these are fully funded federal benefits, at least with respect to contributing employers. In the history of unemployment compensation, anytime a benefit is fully funded by the federal government, like back in 2008, where there was extended and emergency unemployment compensation, employers were not charged for that. So if you get a fully funded benefit, a contributing employer, your normal tax-paying employer, which incorporates most employers out there, is likely not going to be charged. With reimbursing employers, it's going to be a little different. It's still not clear, but there is a section of the Act 2103 that suggests that reimbursing employers, which include governmental employers or any nonprofit employers who've elected to be reimbursing under the Employment Security Act, they may be billed for half of the charges that are paid out. That is just my best educated guess right now. We really don't know how the charging is going to occur. We're hoping for some guidance from the Unemployment Insurance Agency, but that is the best that we can do right now. But even if you are a reimbursing employer and it looks like perhaps you might get charged for half the benefits, the governor's most recent executive order, which is EO 2020-24, has specifically said that benefits paid to, quote, laid off workers or workers placed on, quote, leave of absence shall be charged to the non-chargeable account of the employer. And a reasonable interpretation of that is anybody who's laid off or placed on leave of absence because of any of the COVID-19 issues are not going to be charged for benefits. And that includes both contributing tax-paying employers as well as reimbursing employers. So there's kind of a conflict between the state law and the federal law. We'll have to see how the charging works out. All right, now these benefits, I'm sure many of your laid off workers are asking you, when can I expect to receive these? Realistically, I don't believe that any employees will see this until about 2 or 3 weeks. The states are required to enter into an agreement with the U.S. Department of Labor before these benefits get paid out. I think that will happen fairly soon. But then after that, the weeks that they're eligible for these benefits, they'll have to wait another 2 weeks because you certify for unemployment every 2 weeks. So my best guess is that employees will not actually receive these benefits until about 2 to 3 weeks from now. Somewhere in that neighborhood, they may collect those benefits. All right. All right, the next, can I get the next slide, please? I believe that's 21. 21 is some general unemployment insurance benefit information. The Unemployment Insurance Agency has been overwhelmed with claims, absolutely more than they've ever had in the history of that organization. And what they've started to do is recommend that people file claims based on the first letter of their last name at various different times. So if your last name starts with A through L, you file on Monday, Wednesday, Friday, M through Z, Sunday, Tuesday, Thursday. Generally speaking, the website is the best place for employees to go to file their unemployment benefit claims. It can also be done via telephone, but the website is absolutely the best place to file. And the agency has had so much traffic on their website that people have been able to get through. They've been dropped off the site. They also recommend that if you're going to go on the website to file for claims, try to do it between 8 p.m. and 8 a.m. Do it in the middle of the night when there's less traffic, and there's a better chance that your claims will actually go through and you won't get kicked off the system. All right, next section, please. With that, I'm done with my section. Keith, would you like to take up on yours now?
You bet, Marcus. The most important question, I think, though, is are you out of your PJs yet?
I'm not out of my PJs. And also, my computer just went blank again, and I have no idea what slide we're on, but I'll make do.
All right. Well, thanks, Marcus, for that. While I speak about my portion of the webinar here, I'll let Marcus check on some of those questions, and then maybe he can get back online and try to answer some of the ones we have in the queue. But part of why we do these webinars is to kind of connect on issues that are, arising across clients that are common for everybody. And a critical issue that many of you are dealing with or have dealt with, and you saw it in the news today, is what happens when essential workers decide, I'm not coming to work. I don't want to go to work. You probably saw in the news this morning that Amazon Staten Island facility workers are on strike. They're claiming that they need a deep cleaning of the facility because they had a coworker who tested positive for COVID-19, and they're on a strike. And you say, well, wait a second, they're not unionized employees, are they, at Amazon? No, they're not. But remember that non-union employees have a right to strike. We saw that with the Fight for 15 and the strikes and walkouts at a number of the fast food restaurants in the previous years. So, and then Instacart, this company that helps deliver the groceries for a lot of the grocery retailers, is threatening a strike as well. So this is real. This is happening. And my guess is as we get more and more cases, unfortunately, in Michigan, I think more and more people are going to say, hey, wait a second. Do I really want to go to work? Why shouldn't I stay at home? And that may be exacerbated by what Marcus just told us, which is that the federal government is going to fund $600 on top of any state unemployment benefit per week. So if you have an employee who's making $962 on unemployment, which is the max, if they max out, well, what does that mean? I think if you crunch the numbers, and I'm a lawyer, not a mathematician, but I think 960, when it's loaded up, it's about $75,000 a year. So, why wouldn't I stay home? I might be less at risk, that sort of thing. And so what we have been doing, and let me tell you, this issue is nuanced, okay? It depends on your industry. It depends on your company culture. It depends on all the different policies you have. And I would encourage you to walk through this with your Miller-Johnson employment lawyer. Go through your strategy, make sure that you've thought through exactly what you want to do, prepare your communications, whether they're Q&As, whether they're an email or a memo to all employees, whatever it may be. But my goal this morning is to identify kind of 4 buckets or issues or strategy items that I think are relevant for consideration and that I've dealt with in my advice to clients and that I know my partners have done as well. So you got an essential worker, they don't want to come to work. What's the first thing we need to do? To me, this is about leadership, right? This is a crisis. And in my time, I go back to my Navy days, and I remember when, you know, we were under the gun or we had an issue or we had to respond to an emergency, or frankly, we actually were responding to a gunship in the Mediterranean that was firing on another ship. What is everyone on that ship, in that crew, in your workforce, where do they look? They want guidance and leadership. Leadership, this is an opportunity. And so if you're going to ask your people to come to work and they say, well, wait a second, or are we an essential business? Wouldn't it be great if the leaders are out in front of that? And many of you already are, I know that, right? You've probably already communicated with your employees, but have you been in the warehouse? Have you been on the floor? You know, has your C-suite gone around and thanked people for coming to work? So I think that's an important consideration. Whatever works for you, whatever your style is, view it as an opportunity for leadership. Let's make sure you explain and clarify misunderstandings. A lot of scuttlebutt around, hey, why you an essential business? Well, you know, if you're going to work at Meijer, it's pretty clear, or, you know, Spartan Nash or Kroger or a grocery store, it's pretty clear that you're essential. If you're going to work at a doctor's, at the hospital, it's pretty clear you're essential. That's obvious. But if you're a manufacturing plant with 500 employees, do all your employees know all the products that you're making? Do they know that you're manufacturing, I don't know, face shields or parts that go into ability to give vaccinations, or logistics? Maybe you got, you know, somebody in your supply chain, you know, make some part of a respirator. If those things aren't clear to your people, then they may not understand why they're being asked to work. And I think when they understand that, they're more likely to maybe not decline the opportunity to work. Okay, so explain, clarify misunderstandings, explain why that work is essential. If you've worked with Miller-Johnson on this issue, on whether you're an essential business, you've gotten letters of delegation to all the critical infrastructure workers in your organization. If you haven't included specific bullet points and details, think about whether that may help you as you move forward if you think some of your workers may refuse. And the last bullet here on 1 is make sure they understand what you're doing to keep them safe, right? You're following the CDC guidelines. You have checklists for visitors, right? You're doing the deep cleaning. You're doing the social distancing. All of the things you're doing and everything on top of that. So you're not just complying with the executive order. You let them understand if you're taking temperatures of folks with the scanner, which we now know is finally lawful, the EEOC has said. So there's some doubt about that early on, but you're scanning temperatures. Anything you can do to make your folks feel at ease, your employees feel at ease, is critical. So that's the first point, and it's first bucket. So let's go to the second one. Okay, that didn't work. We just have some people that are like, you know what? We're not coming to work. I don't feel safe. I don't want to come, whatever. So the first question is, wait, isn't this a quit, Keith? Aren't they just refusing to work? Well, I don't think it's that easy, right? You know, if they honestly say, you know what, I'm quitting. I don't want to work here because this is, you know, not right, and I'm quitting. Document it. And then if you've got great solid facts, good for you. I think it's more likely people are going to say, hey, I don't want to work because I don't think it's safe for me and my coworkers. I don't want to work unless you do this. Oh, by the way, you know what? I think you're stretching this. I think you're making us work, and I don't think you're essential. Talk to my neighbor. He's in manufacturing or he's in this service, provider. He's in construction, she's in construction, and they're not going to work. So I think you're wrong about this. And maybe they call the hotline on you. I don't know. But what have they just done potentially? Right? Well, I don't think they've quit. And if you just say, hey, we're going to deem you a voluntary quit, you may have taken an adverse employment action against them. You likely have. And so it's really fact dependent. I'm not saying that people can't, the facts may support a quit. Great. That's awesome. Then they're done. They've decided to leave your organization. You can part ways. More likely it's going to be in a gray area. And that's where you get the practical and legal considerations. Okay. And so the practical considerations, which I think are very important, right? Employee engagement. You have talented people. I mean, let's face it. We watch the news. Detroit's not looking great right now. There's some significant concern across this state that we may be in a position, hopefully not as bad, but maybe similar to New York and the surrounding areas. And you're going to have a lot of great quality, talented people that have maybe legitimate concerns that, hey, I'd prefer if I could just stay home all of April because that would make me feel better. And you don't want to lose those people, right? And so, you got to think about that. And then you have PR concerns, right? I mean, what if you're the business that is out there making people work? Is that the message you want to send? So practical considerations, obviously, those are all unique to your organization, but I want you to think about those. Legally, is the employee, when they refuse to work, engaged in protected activity? National Labor Relations Act. We talked about Amazon, Instacart. Those employees are on strike and they're protected, right? Unless they lose that protection, if they bind together, and many of you have probably heard about, concerted protected activity, that's not a strike. But non-union employees can strike. They can engage in concerted protected activity on behalf of others. And that could easily be protected. If it is, and you fire them, well, now you have legal risk. What about the Whistleblower Protection Act? If they reasonably believe that you're not in compliance with Governor Whitmer's executive order on shutdown, are they reasonably reporting a suspected violation of the law? Maybe they're protected that by OSHA. Anyway, you guys understand all the different legal risks that can come here, I think. But I think it's important to look at the facts and say, okay, should we discipline or discharge? If someone just doesn't show up for work and they don't tell you why, and you have no reason to believe that they're engaged in protected activity, of course you can discipline and discharge, right? You follow your policy. If they don't show up for work, they get an attendance point, you follow your policy. What I'm talking about here is when they say why. And when they say why, I think that opens up some factual issues that you got to think about both practically and legally in terms of managing your organization's risk and just saying, hey, you guys are done. You're out of here. You're fired. We're deeming you a quit and your employment is over. So some things to think about. So one of the options that I've explored with a number of clients, and I know others in our group have as well, is why don't we just put them on the shelf without pay? Let's just put them on an unpaid leave. Can we do that? The answer is yes, you can. And that has some effects that we're going to talk about next. So if you decide not to discipline or discharge because you think you have facts that create some legal risk, and you decide they're not confirmed quitting, so there's some gray area here, or they've clearly engaged in protected activity, what if I put them on an unpaid leave of absence? What are some of the benefit issues? Well, remember here, they are refusing available work. This employee or this worker has made a choice not to work. And I would say pin that down, right? Are you refusing to come to work as scheduled? Yes. Pin that down, nail that fact down. So now they're withholding their labor from you. If they're withholding their labor from you, you don't have to pay them and you don't have to continue their health care or other benefits. Right? There's some great case law in the context of the National Labor Relations Act that says when employees go on strike, which is withholding their labor from you, you don't have to finance that strike. You don't have to continue them on your health care insurance. And that may be a nice I mean, it's a stick approach, but it may be an approach that you say, hey, look, you made that decision, but, you're not going to get paid. Maybe you tell people then you're not going to be eligible for health care. Obviously, you got to follow your policies. You got to follow your plan documents. If you have a collective bargaining agreement, any terms or conditions that apply, you got to follow there as well. But that's a potential stick there. Now, some clients would say, well, we don't want to put our good people off without health care. I get that position as well. But that's something to think about. Okay. Is it going to be enough? You're off without benefits. Is that enough to defer folks from refusing to work? Right? Well, another thing I think you can tell them is, look, we need people essential to our business to operate so that we can come out of this on the back end as healthy as we were when we went into this. If we can't meet our essential functions during this shutdown, we may not have as many jobs on the back end. And I think it's perfectly lawful to tell employees who are committed and loyal to you, hey, we're going to reward those people because they stuck with us. They're the ones that are going to have a job. And when somebody gets, self-selects not to work and they get put off on unpaid leave, assuming you don't discharge or you deem them a quit, you put them on that sort of temporary status without pay or benefits. They don't get to come in and bump people absent some collective bargaining agreement provision, which likely wouldn't apply here depending on how it's written. But I think you can tell them, look, if you think you're just going to come back and you're going to bump everybody that's been here working, no, we're going to reward those people. And I think that is another kind of stick approach. So just some ideas and thoughts there on the benefit piece on how to do that in the messaging. And again, I go back to what I said earlier, figure out the best way to communicate. Figure out what strategy you want to take. If you haven't done this yet, think about what if a number of employees decide not to work? What are we going to do? Are we going to communicate? What's our position going to be on leave versus maybe potential discipline? If we do put people on unpaid leave, which I think is my preferred approach if I'm talking to clients, what are we going to do while they're on leave and what are we going to tell them? What messaging are we going to give them? And then the fourth bucket or issue is a huge one. This is a huge one, right? Because it's easy to go on unpaid leave without, maybe even without benefits if I'm going to get $600, $700, $800, $900 a week in unemployment. So the money question that you guys are all wondering is, well, they refused, right? They're refusing available work. They don't get unemployment. Absolutely true in ordinary times. Refusal of available work is going to be a voluntary quit, and we think that you should take that position that they may not be eligible for unemployment because this would be a voluntary quit in our eyes. Or even if it's not a voluntary quit, you're refusing available work. That's probably the better way to say that. Now that I say it aloud, sorry if I misspoke there, but I would not call it a voluntary quit necessarily. I'd say they're refusing available work that renders them ineligible, and therefore they don't get the benefits. Okay, and I would take that position if I'm giving the advice, and you wanted to make sure people come to work. They need to know that, hey, you're probably not. We don't think you're eligible for unemployment. Okay, you might even go as far if you want, depending on your culture, you may want to say, well, and we're going to challenge it. I mean, you have the right to challenge that. Now, here's the wrinkle, and that's Executive Order 2020-24. If you've read this, you probably know what I'm talking about. But there is paragraph 1 of that executive order relaxes the voluntary quit rule for certain COVID-related reasons. Okay. I think the best way to read that is all the other voluntary quit provisions should still apply. And I think that's the best way to read that, and I think employers can win that argument. It's a little unclear, however, because another section of that executive order, and I'll be interested for Marcus's viewpoint on this as well, is that the actively seeking work and available for work requirements are also suspended during this period of emergency pandemic. So does that mean that there's some gray area or ambiguity that the state may say, hey, you don't have to be actively seeking work. We've said the voluntary quit rules are not going to be strictly applied, so maybe we're going to give them benefits. I think the better argument is they shouldn't be entitled to it, and I hope Governor Whitner, especially for essential workers, clarifies that, right? The last thing we need is the governor in the state of Michigan sanctioning people to refuse to work in truly essential or critical jobs. Can you imagine that? I mean, how would that work? Oh, state of Michigan, says that you don't have to work in an essential job function. Think of care just alone. I mean, is that really what our governor meant or wanted? I don't think it is, and I'm cautiously optimistic that that will get clarified. But I do want you to know that there is a potential argument that they may be entitled to benefit. And as many of you know, who decides this? Well, it's the unemployment agency. And I know a lot of you have been in front of ALJs, and the truth is they give up benefits like candy. And so we're going to be fighting that uphill battle, in many, many cases. And so while we should be firm, I think, in our advice and our communications to employees that they're not likely going to get this, I think you have to acknowledge as an employer that there may be a chance they do get it, or certainly a fight about it. So I would tell employees they're not eligible and that you may even challenge it. Here's another wrinkle to this. I think this is a very good additional argument employers have against these type of people getting unemployment benefits, who refuse to work when the duties that they have are essential, critical infrastructure work. They're essentially on withholding their labor from you. And there is a provision in the statute, the unemployment statute, that says you're disqualified if you're a striking employee. And the phrase used is labor dispute in the statute. And I think there's an argument, a fairly good one, I think, that, hey, if you have a labor dispute with your employer, Keith Eastland doesn't want to come to work because Marcus Campbell won't clean the office, and I think he was exposed to his mom who had COVID. I'm not coming to work for that. We have a labor dispute. We have a labor dispute about the conditions of my employment, and I think arguably then Keith Eastland becomes disqualified. And I like that argument as a backup as well, because I know that the executive order doesn't address that disqualification provision as to striking employees. Again, it remains to be seen. It's something that we'll have to wait and see what the unemployment does. And maybe the governor will clarify her executive order, or we'll get some guidance on that. And the last point on this slide is simply that just remind people that if they think they're going to go get this $900 a week, go ahead, I guess. We're going to fight you on unemployment. And even if you're eligible, at best, it's going to be 2 or 3 week delay. And maybe for some folks, that's a deterrent in and of itself.
Yeah, Keith, if I may chime in on this a little bit.
Yeah, you bet. I'm curious to get your perspective.
The executive order, number 24, is very, very broad. Any type of eligibility criteria, which are normally things like you have to be able to work, you have to be available to work, you have to be seeking work, those are out the door now. Those are essentially thrown out for practically everyone, especially anyone who's unavailable because of COVID-19. But that doesn't mean some of the other disqualification provisions don't apply. One is the refusal of suitable work. If somebody is receiving unemployment and you provide suitable work for them and they refuse it, then they are disqualified from receiving benefits. And I think that will disqualify them from both the state benefits and the federal benefits. So there are some proof issues. As Keith had mentioned, you judges like to hand out these benefits like candy, but at least it's something that you can point to and say you are refusing suitable work, so that's a basis that you're not entitled to unemployment benefits. And that might be helpful in convincing individuals they need to come to work.
Yeah, I like that a lot, Marcus, right? The suitable. And now I agree with you. There may be some factual questions there about, is it suitable because you're making me work when you're really not an essential business, or you're making me work in an abnormally dangerous situation because you're not taking all of the precautions. But I think, to the extent employers are following it and feel strongly about that, then they can win those proof issues. No, I like that a lot. That's helpful. Well, do you want to take a look at some of the questions, Marcus, that we got, and maybe go through a few of those? I think we're coming up on an hour, but we can probably go a little bit over.
Yep, I've tried to answer some of those as we can, but I'll go through and I'll find a few other ones that we have here. One of the questions I got is the $600 going to be retroactive for most employees? And the answer is no, it will not be. Only for the independent contractors, gig workers, people who never got unemployment before. Technically, it says it's going to be retroactive for them. Everybody else, which is just about all the employees that we're all concerned with here today, it's only going to be moving forward and only until July 31st.
Marcus, can you speak? I got some questions on the earlier webinar as well this morning about hours reductions and how that plays into this, and would they still maybe be eligible for unemployment and this additional $600 federal benefit?
Yeah, absolutely. And the answer to that is I'm not 100% sure. But if I believe anybody who's maybe isn't completely unemployed, let's call them partially unemployed, somebody whose hours have been reduced, they still can file for and collect a reduced state unemployment benefit. So if you normally work 40 hours a week and now you're working 20, you can still file for and be eligible for a reduced state unemployment benefit. So that is absolutely the same. That hasn't changed. Workers can still continue to do that. However, are you going to get the additional $600? And the answer is, I don't know. I believe that if you file and you get a reduced benefit based on your earnings that you have made during that week unemployment, if you get any benefit, let's say it reduces your benefit from $362 down to $75. I believe that if you get any benefit whatsoever, you're going to get the $600 in addition to that. But I believe that if you made too much money and you're not entitled to any state unemployment benefit, I don't think you're going to get a state benefit or the $600. That's how I think it's going to be administered. But to be honest, I don't know. Based on what the law says, you should get that $600 no matter what. But I don't think it's going to be administered that way. We'll have to wait until we get more guidance from the Unemployment Insurance Agency, which according to them is forthcoming.
And Marcus, the flat $600 on top of the state benefit, will those be made in the same payment, do we think, or do we think that they may be split up?
Yeah, I think it will be made in the same payment. The states have the ability to split those up, but I imagine that the agreement that the state of Michigan hashes out with the U.S. Department of Labor is going to put them all into one benefit, into one payment. So I don't think there'll be a separate application process. I think they're going to include it all into one benefit so that when you call to certify for benefits, when you do that, you'll be certifying for both your state unemployment benefit amount and that federal benefit. And let's say you qualify for the max on both, you'll get $962 that week. You'll get a check that includes 2 weeks worth of $962 benefits because currently with the UIA, they send out checks every 2 weeks. Well, actually no checks. It gets direct deposited or put onto a reloadable debit card for you. And it's done in a 2-week block. So I don't think it'll be a separate process. It'll all be one and it'll come as one payment.
And I know, Marcus, that the benefits are not retroactive. The extra $600 for employees is not retroactive back to January like it is for those independent contractor group under 2102. But, could the $600 be retroactive to, this week since the law got passed Friday? if it takes a week to get this agreement between Michigan and the DOL, any indication or thoughts on that? My understanding was that was unclear, but I wondered if you had heard anything.
Yeah, I haven't heard anything, but I do think that as soon as we get to a week in which, let's say, the agency signs their agreement with the Department of Labor today, I think starting with this week of unemployment, that those $600 benefits will be paid. They're not going to be paid until about 2 or 3 weeks from now, but I think it would include from the moment that the agreement is signed. So any week of unemployment that covers the week in which the agency signs that agreement with the Department of Labor, that's when it's, I think, is going to go active. So sure, they'll, I think, eventually be able to get it for, let's say, this week and next week, but it's not going to come. That check's not going to come for 2 to 3 weeks.
Great. And I got a question here back to the piece that I spoke about, and is, if an employee doesn't feel safe and goes home and they can't work remotely, and you put them on the shelf, sort of the temporary leave without pay, can they qualify for the Families First Corona Response Act, the 2 weeks of paid sick leave or expanded FMLA? And the answer to that is, if the only reason is they're refusing to work, then no. They would have to meet one of those separate, specific, listed, you're subject to a quarantine order, you're subject, to, or you have a child care need. Those specific things would have to be met. So just because you're at home and refusing to work alone is not going to be enough to trigger those sick leave benefits under the federal law. And one thing that I would like to clarify too on this webinar is that we had a number of questions, and Miller Johnson explained its position under the Family First Corona Response Act, that the paid sick leave, the 2 weeks paid sick leave, and the expanded FMLA, well, mostly sick leave because the FMLA wouldn't apply, but the sick leave, when it talks about being subject to a quarantine or isolation order as a reason for getting those 2 weeks of paid sick leave, that does not include a shutdown order like Governor Whitmer's, right? The DOL has clarified that they agree with Miller Johnson's position on that, and there's a frequently asked questions section on the DOL's website that makes that clear. So if somebody's laid off simply because you don't have work for them because you've been told you can't run your business or you can only run a central part of your business, those people are not going to get the 2 weeks paid sick leave for that reason alone, because that is not an isolation order or quarantine order under the new federal law. Okay. Any other questions, Marcus, you want to handle here?
No, I think I am done, and unfortunately, my computer has logged me off again, and I can't see any of the questions that were on there. I will do my best to respond to those. But Keith, thank you for stepping in and helping out. I want to thank everybody for attending this today. If you have any follow-up questions, please feel free to contact either Keith or me or anyone at Miller Johnson, and we will do our best to get answers for you. And we just want to let you know that things are changing by the day with respect to the laws on these issues, and we will keep you informed as much as we possibly can every day at 4 p.m. We send out our email alerts to clients regarding all the COVID-19 legal issues. So sign up for those if you haven't, or you can check our website. But we tend to do that all at one time at 4 p.m. every business day. So today I'm sure there are going to be a bunch on there. But otherwise, we thank all of you for attending with us today. And any questions, feel free to give us a call. All right. Thank you.
Great. Thank you, everyone.